Belsky appearing on behalf of Kyle Burmeister, Revocation. State your name, please, sir. Kyle Burmeister.
What you're about to watch isn't just another routine courtroom appearance. This is a moment where a man's freedom, credibility, and future all collide in a matter of minutes. The defendant, Kyle Burmeister, stands before Judge Simpson facing drug-related charges that could fundamentally change his life. On one side, the defense argues confusion, treatment, and recovery. On the other, the state paints a picture of deception, evasion, and intent to distribute narcotics. Right out of the gate, you hear the word adjournment. That might sound procedural, even boring. But in criminal court, an adjournment can be the difference between walking out the door or being taken into custody. The defense is asking for time. Time to resolve another case. Time to stabilize bond. Time to manage damage. But in a courtroom, time is a luxury that has to be earned. Judge Simpson isn't just a referee here. He's weighing credibility, compliance, and public safety. Did this defendant follow bond conditions? Did he know what was required of him? Or is confusion being used as a shield?
Your Honor, we are requesting an adjournment to possibly resolve this case along with his other pending misdemeanor case in Ms. Bondi has. So I'd be asking for a 2-week adjournment, and then I can address the bond issue.
You need to address the bond issue before I'm going to give you an adjournment.
Your Honor, my client tells me he never had noticed that he had to go to community corrections on this case. And I am looking at the court activity from this file, from the arraignment that he was given. It only indicates bond amount 5,000, personal recognizance. There's nothing listed in the conditions section. I went through all this paperwork and said he's kept everything.
Except he was advised on the record that he would be subject to drug testing on that same date by Magistrate Odetella, and I have that form. So I'll match my form against yours anytime.
Well, all I can add, Your Honor, is that he actually had.
Why didn't he go?
Inpatient treatment.
Did he go over?
He tells me he didn't either recall or didn't have anything to explain. I think once he was released from jail. Any paperwork that said I had to go. And so maybe with the confusion of these cases, the good thing though, Your Honor, is I have verification. He went to the JIRA residential from February 25th, and he completed that actually early on March 7th. He can test today. He's telling me he should be fine. He is not in.
I'll pass it. He needs to get over there and test now.
Thank you.
This is the first turning point. The defense is doing everything it can to frame this as confusion, not defiance. Missed paperwork, overlapping cases, a defendant who didn't recall his obligations. And then comes the emotional appeal, residential treatment, early completion, willingness to test today. But listen closely to the judge's posture here. Judge Simpson isn't debating whether recovery is hard. He's focused on one thing: compliance. In criminal court, bond is a contract. You are released under conditions. Those conditions aren't suggestions. They are orders. Whether a defendant remembers them is secondary to whether they followed them. The defense tries to reframe this as a system failure. No clear notice, conflicting paperwork. But judges see this every day. And from their perspective, "I didn't know" is the most common explanation in the room. The court's message is simple. If you're out on bond, your job is to prove reliability. You don't wait. You don't drift. You don't negotiate later. You show up.
Court does call the case of the people versus Kyle Burmeister.
James Belsky on behalf of Mr. Burmeister, who is approaching. We are in receipt of the community corrections report. I can advise the court that it is my understanding, and I believe he actually has the pill bottles to verify, he has prescriptions for the benzodiazepine and buprenorphine. My client does not have a prescription for alcohol.
He certainly does not, and that's prohibited, Mr. Allen.
Your Honor, if I could just make one.
Go ahead, make your argument. I'll let you say what you're going to say.
Records I have obtained so far have shown me that leading up to and prior for probably several years, Mr. Burmeister has been a patient at Washtenaw Community Mental Health. He also sees addiction specialists over at IHA at St. Joe's Hospital. is his aftercare, which he is continuing after he completed the residential Oakdale Recovery Center, which I have proof right here. So we have a situation, Judge, where somebody who is struggling with addiction, doing as much as he can to address that, to be clean and sober, and getting help from several medical professionals. My request, Your Honor, is that the court consider the ankle alcohol tether to monitor him 24/7. I know he wants to be sober. He's just struggling. And as far as addiction, this court is well aware that it's not an easy process. So I would ask that you keep him on bond with condition that he be on the tether.
He didn't go to community corrections. We sent him over to community corrections. He comes back positive.
I understand, Your Honor. For at least several of those weeks, he was in program. And I have proof to verify that. So getting help, detoxing, getting inpatient rehab care.
Set this for April 3rd, 2025, 9 a.m. I don't need a response from the people. Defendant's bond is revoked. Defendant's remain.
And there it is, bond revoked. That's not symbolic. That's immediate loss of freedom. The defendant doesn't walk out. He stays in custody. What's striking is how fast it happens. The judge doesn't invite rebuttal. No extended debate. No second round of persuasion. That tells you the court's internal scale already tipped. From Judge Simpson's perspective, this isn't about sympathy, it's about risk. Missed conditions plus drug-related allegations equals instability. The court is asking, if this person can't follow basic bond terms, how can they be trusted in the community? The defense asked for an alcohol tether, a monitoring device meant to prevent violation. But the judge chose a different tool, detention. That's the system saying, we've moved past trust. This is where the courtroom becomes brutally pragmatic. Addiction may explain behavior. It does not excuse it. The law draws a hard line between struggle and compliance.
I believe that the facts set up everything that's needed for count one, as it clearly shows that it's a substance, controlled substance, it's cocaine. It was tested by the True Narc. In this case, Officer Hussein had testified about finding the narcotic residue inside the vehicle. Then the two larger bags, which were found at the hospital. In this matter, the defendant was the only one in the bathroom at the time in which these narcotics, or prior to these narcotics being discovered. He was informed not to flush the toilet, did so anyway, was also informed not to basically make sure that he could be visualized. In this case, he saw that he bladed himself towards the trash can, away from the view. There was fervent movements with his hands. And then all of a sudden there happened to be, while he washed his hands, there's two baggies of one bag of cocaine, one bag of crack. It just happened to be wet at the time in which generally right after he washes his hands, Your Honor. So it's been tested and shown as far as count one is concerned. But when it comes to count two, Your Honor, I believe Officer Hussein's testimony is very relevant into the indications of narcotic trafficking in cells. It's our position, Your Honor, based on the fact that there was a scale there, multiple small baggies numerous small baggies for packaging, tear-offs, which are commonly used as packaging, two different types of narcotics placed in two different bags, both of which are above the normal use for personal use. In this matter, we have one at 14, I believe one at 30 grams, Your Honor. One of those, I believe, which would be the cocaine, this pure cocaine, Your Honor, 30 grams, that's over an ounce. He had over an ounce of cocaine and then approximately half an ounce of crack cocaine, Your Honor, with baggies, with the scale. Those are every single thing beyond our address book that one would need for distribution, Your Honor. So we do believe that there is more than enough probable cause to sustain the additional charge that the people had requested, which was a possession with the intent to deliver, which would be a delivery of manufactured controlled substance less than 50 grams. We showed that the total weight of this was 45 grams, Your Honor, just under that 50-gram threshold, and that it was all cocaine or a mixture that contains cocaine, Your Honor. So for those reasons, and of course, we've already established venue, time, location, and identity. So, Your Honor, at this point, we do ask that the court bind over on the original count 1 and the added count 2 of delivery and manufacturing of a controlled substance less than 50 grams.
Now the case pivots from bond to substance. The prosecutor lays out a narrative that's carefully constructed. Residue in the vehicle, larger bags at the hospital, bathroom isolation, refusal to follow instructions, wet baggies, hand movements. Every detail is meant to build a chain of inference. Then comes the escalation. This isn't just possession. This is intent to deliver. And that distinction matters. Possession is serious. Distribution is catastrophic. It changes sentencing ranges, exposure, and leverage. Notice how the state emphasizes quantity and tools. 30 grams of cocaine, half an ounce of crack, baggies, scale. In narcotics law, these are not neutral objects. They are interpreted as purpose. The law allows prosecutors to infer intent not from confession, but from context. This is how criminal narratives are built. No one has to see a hand-to-hand sale. The courtroom accepts patterns, amounts, packaging, behavior.
Thank you. The first element of this, of course, is that the defendant possessed a controlled substance, in this case, the allegations, cocaine and crack cocaine. There was a pat-down and a full search before the hospital, before any of these allegations happened, by trained law enforcement officers. They know how to do the searches. Well, Officer Colorasi was in training, but also trained to do a search, obviously. Nothing was found on my client's person. Nothing in his system from the blood draw. No drugs, no alcohol. So really the possession comes down to these 2 bags that were found in the trash can in the hospital bathroom. A bathroom that is open to the public 24/7, doesn't require any special entry. Anyone could walk into that hospital and use that bathroom. I was curious how often they cleared the trash can, but the officer from the hospital didn't know. So obviously those bags could have been there for any amount of time. The officer from the hospital testified that my client had irregular hand movements, but at the end of the day, all he said was, well, he was drying his hands for an irregular amount of time or something to that effect. I mean, that's, I just don't think there's a lot there to support probable cause, respectfully. And no one saw my client put anything in the trash can.
This is the defense's battlefield. Constructive possession, a legal concept that decides whether proximity becomes guilt. The attorney does exactly what a skilled defender should do: pull the court out of emotion and into doctrine. Public bathroom, unknown trash history, no direct observation, no drugs on his body, no substances in his blood. The argument is surgical. Show me the bridge between him and the baggies. This is where criminal law becomes philosophical. Does being near something make it yours? Or does ownership require control? The defense cites appellate cases for a reason. Judges respect precedent. What they're saying is simple. Suspicion is not possession. You can look guilty. You can behave oddly. But unless the evidence connects you to the object, the law should hesitate. Viewer question: if no one actually saw him discard the drugs, is proximity enough? Or should courts demand a higher standard before labeling someone a trafficker?
And of course, Your Honor knows there's 2 types of possession, right? Actual and constructive. Presumably the people are arguing both, that he actually possessed these, but that nothing was found on his person. Constructive possession is, of course, and then there's case law, I think Mr. Danner is aware of. There's a Sixth Circuit case interpreting Michigan law, and there's a Michigan Supreme Court case, and I have the citations, I'll mention them quickly, but basically proximity to contraband is not sufficient proof for possession, for constructive possession. There has to be something else connecting a defendant to the contraband, whether it's a weapon or a controlled substance. And I won't go through a lot, but I would just like to, for the record, say that I'm referring to a Sixth Circuit case, Parker v. Renico, 506 F. 3rd 444, interpreting Michigan law, decided October 17, 2007. And that case cites many cases, including a Michigan Supreme Court case, People v. Wolf, WLFE 440 Mich 508, decided in August 31st, 1992. Very briefly, what the Sixth Circuit says is, as with the federal rule, a person has constructive possession if there's proximity to the contraband, together with indicia of control. In other words, proximity alone never suffices. Cites the Michigan Supreme Court case. And the ultimate question, according to the Michigan Supreme Court, is whether the evidence establishes a sufficient connection between the defendant and the contraband to support the inference that the defendant exercised dominion and control over the substance.
This is where theory meets authority. The defense anchors its argument in Michigan Supreme Court doctrine, dominion and control. The law does not criminalize coincidence, it criminalizes possession. But watch what happens next. The judge doesn't debate the rule, he applies it. Judge Simpson accepts the legal framework and still finds probable cause. That's important. The court isn't rejecting the defense's law. It's rejecting the defense's interpretation of the facts. In the judge's view, the behavior, location, timing, and circumstances form a sufficient connection. Preliminary hearings are filters, not verdicts. The court is not saying guilty. It's saying this deserves a jury. That's the power of probable cause. It doesn't convict, it advances. And once a case is bound over, leverage shifts. The stakes rise, negotiations change. Pressure increases. This is the machinery of the system. It doesn't resolve doubt, it moves doubt forward.
That's beyond the mere proximity. So I respectfully assert that there is not probable cause on that first element for actual or constructive possession. The second element, defendant knew that he possessed a controlled substance. That would have to be inferred. There's no evidence of that. There's no statements or admissions. So that would have to be inferred from the first element. And, well, there is testimony of the weight. So that's the third element. So for all those reasons, well, I'll leave it at that. Thank you.
I really don't need rebuttal. The court would find that the people have sustained their burden of showing sufficient evidence that there's probable cause to believe that the defendant committed the offense of possession of a narcotic less than 25 grams. Also, given all of the testimony, in particular that by Officer Hussein, there is enough. This court believes that the defendant should also be bound to stand trial on the additional charge of possession with intent to deliver a controlled substance less than 50 grams. And so the court would bind the defendant over to circuit court on both those counts. The court would also indicate that the issues that are raised by the defendant with regards to those cases and actual possession, the court does find, for the purposes of probable cause, that those particular prongs under either test are met. To the extent there might be an argument as to what could be inferred or the intent, that this court would believe would become a question of fact that would properly be before the jury. But I think there's enough there to bind the defendant. Well, I know there's enough there to bind the defendant over. Defendant's bound over on.
Judge Simpson's ruling closes this chapter with clarity. The court finds enough evidence to proceed on both possession and intent to deliver. The defense's arguments remain alive, but they now belong to a jury. What we witnessed is the justice system in its purest form, not declaring truth, but deciding whether a story is strong enough to be tested. Addiction, confusion, recovery. Those themes remain human, but the law demands structure. Kyle Burmeister leaves this courtroom not as a man misunderstood, but as a defendant advancing toward trial. The bond is gone, the charges stand, the path forward becomes narrower. This case illustrates how quickly legal posture can shift. One missed condition becomes detention, one inference becomes a trafficking charge, and every word spoken becomes part of a permanent record. Courtrooms don't deal in sympathy, they deal in standards. And today, those standards moved this case forward. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.